A child walked into a school building in Buffalo. A man followed him. Minutes later, that man was tackled by a staff member and arrested for attempted abduction. The child's parents were never told. The only reason anyone found out is because a detective got a copy of deleted surveillance footage handed to him by a staffer who secretly recorded it on a phone. The official footage was erased. The family found out from the district attorney. That detective's name is Richard High. He's not a political actor. He's not a teacher. He's not a disgruntled parent. He's an SVU cop, 13 years on the Buffalo police force, 2 years assigned to child sexual assault cases. And he says the school system in Buffalo doesn't just fail to report crimes, it suppresses them, it obstructs justice, it hides victims, and it ignores subpoenas. High laid it all out in April 2025 on a podcast, then on camera, then in court filings. Within 48 hours, over 650,000 people had heard what he said, and what he said was specific. He claimed the Buffalo Public School District routinely labeled child sexual assault reports as information only to prevent them from being investigated. He said subpoenas from law enforcement were ignored, signed by judges, handed to the district, and left unanswered. He said school lawyers told staff not to cooperate with police. He said the district's internal priority was to protect its image, even if that meant allowing predators to remain in classrooms. And he brought receipts, audio files, case logs, firsthand interviews, paperwork that the Erie County District Attorney's Office confirmed is now part of multiple investigations. One of the cases High named involved a high school girl who reported to her counselor multiple times that her father was beating her at home. She showed the counselor video. She came to school injured. The counselor did not file a report. The girl returned a third time, covered in bruises. Only then was she removed from the home and her father arrested. High says that failure wasn't a mistake, it was routine. Another case involved a student-on-student sexual assault that had been downgraded in the system as non-criminal, an internal label used to avoid paperwork. It only surfaced when High reviewed it manually and flagged it. Then there was the February incident. Shane Cronin, a 30-year-old from out of state, entered Drew Science Magnet Elementary School during dismissal and attacked staff. He had tried to grab 2 children. Only one family was told. The other didn't find out until prosecutors recovered deleted footage. The footage had been removed from the school's official system. A staff member, without permission, had filmed the screen with a phone and sent it to police. Without that footage, the second child's parents would have never known. When the district responded, it didn't deny the incidents. It didn't refute the facts. It issued a short statement calling the claims unfortunate and untrue, not false, not defamatory, just unfortunate. The Buffalo Board of Education immediately called a special session and hired an outside investigator. The district said it maintains a close relationship with police, but refused to explain how subpoenas could go ignored for months. The superintendent wouldn't answer whether surveillance footage had been deleted. She said the district was vigorously addressing the matter. As of early May, Buffalo's mayor has made no public statement, no press conference, no action. To understand what that silence protects, you have to understand what it takes to ignore a subpoena. A subpoena is not a suggestion. It is a signed court order, enforceable by contempt. In New York, if a school district receives a subpoena and fails to respond, the judge can initiate sanctions, fines, or compel testimony through law enforcement. Prosecutors don't send these lightly. They are logged, clocked, and filed. When High says subpoenas were ignored, he doesn't mean delayed, he means bypassed, silenced. There is no procedural ambiguity. You comply or you obstruct. And obstruction, when it involves child safety, is not just misconduct, it's liability. In New York, failure to report suspected child abuse is a crime. It's a Class A misdemeanor. Ignoring a subpoena is contempt of court. tampering with evidence, like deleting security footage during a felony investigation, is a Class E felony. These are not policy disagreements, these are chargeable offenses. And yet, the response from officials has been procedural, not criminal. An investigation was opened, but no one placed on leave. The language from administrators has been therapeutic, not legal, as if the concern is community trust, not obstructed justice. High knew what would happen when he went public. He said as much, that he'd likely be suspended, that he'd face disciplinary review, that the lawyers at Buffalo Public Schools would try to make an example out of him. But he said something else, that after 2 years in SVU, seeing the same obstruction over and over, he wasn't going to wait anymore. His union backed him. The Buffalo PBA said he had done nothing wrong, that his record of service, both in uniform and as a detective, stood on its own. But inside the district, the fear remained. One staff member told reporters, "If you speak out, you're done." High repeated the phrase on air, not because it was dramatic, because it was obvious. Everyone in the system already knew. That's the part most parents don't understand. Your child could be abused, ignored, or nearly abducted, and you'd find out secondhand. Not because someone made a mistake, because someone made a choice. In Buffalo, a second grader was nearly taken from school grounds. His family wasn't told. A prosecutor had to intervene after finding deleted footage. When that fact came out, the district didn't apologize. It called the situation unfortunate. One parent at a school board meeting said they weren't surprised. "We've been saying this for years," she said. "They don't tell us anything unless it's already public." This is what the pattern looks like when it functions. In Loudoun County, Virginia, a school board failed to report a bathroom rape. The student responsible was transferred to another school, where he assaulted again. In Pennsylvania, Penn State officials suppressed reports of child molestation for over a decade to protect the football program. In New York City, the Department of Education removed teachers accused of abuse from classrooms, but let them continue collecting paychecks in reassignment centers, quiet rooms known as rubber rooms, rather than reporting them to police. These aren't the same cases, but they follow the same logic. Reduce liability, manage outrage, keep the paperwork internal, protect the institution. A school system has one job, and when its internal lawyers function like defense attorneys in a criminal conspiracy, when subpoenas don't get answered and evidence gets erased, what you're looking at isn't breakdown, it's function. Because the system isn't designed to protect your child, it's designed to protect itself. And when protection requires silence, you don't get a report. You get a message. This is index red. No masks, no games, just the signal.